Judiciary Committee will come to order, and as soon as she is ready, I'm going to recognize our friend, the Senator from California, who has a word to say. Senator Feinstein.
Thank you, Mr. Chairman, for this courtesy. It's much appreciated. This will likely be his last markup, and I'd like to recognize my chief counsel, Nick Xenakis, who will be leaving the committee later this month to join the private sector. After serving as a judicial law clerk and federal public defender, Nick began his tenure in the Senate as my crime counsel in 2017. As ranking member of the committee, I promoted him to general counsel, where his responsibilities expanded to include the committee's full portfolio, including criminal, civil, and immigration matters. Since January, Nick has served as my chief counsel, advising me on all matters before the committee. He's really been a good advisor. His hard work contributed greatly to some of the committee's most important legislative accomplishments in recent years, including restoration of the Crime Victims Fund. I'm optimistic that before he leaves, Nick's work to reauthorize the Violence Against Women Act with your staff, Mr. Chairman, as well as the staffs of Senators Klobuchar, Ernst, Murkowski, and others, will result in a bill that passes the Senate and the House. For all his successes, I suspect Nick would say his proudest accomplishment during this time with the committee is his beautiful daughter, Bodhi. She's just now starting to walk and talk, and she's doing her best to keep Nick on his toes. It's a testament to Nick and his wife, Caitlin, a successful federal prosecutor herself, that he was able to balance his obligations as a first-time father with the service to the committee. Mr. Chairman, I'd like to ask that you and other members join me in thanking Nick for his service to this committee. He will be missed.
Mr. Chairman.
I'll be right with you. I'd like to take a moment to join Senator Feinstein in saluting Nick Xenakis. He served on the committee staff since 2017, and of course, as Senator Feinstein has announced, he was her general counsel in a critical moment. He's been a mentor to and a friend to many of our committee staff and provided invaluable assistance. I'm sure I speak for all of us in saying we appreciate your service and wish you the very best from this point forward. Senator Kennedy?
Yes. Well, first, congratulations to Nick. We will miss him. Second, quickly, there's a gentleman here today with me, J.P. Barata, who is one of my colleagues I've worked with this summer. He's come down from UVA Law School. He's got to go back to UVA Law School, and from there, he'll go out in the private sector and make a lot of money and pay a lot of taxes, for which we're grateful. But I wanted to recognize him today as well. JP, raise your hand. Thank you.
Thanks, Senator Kennedy. The meeting has 7 items on the agenda today, 6 nominations, 1 piece of legislation. That legislation, S-1787, the State Antitrust Enforcement Venue Act of 2021, sponsored by Senators Lee and Klobuchar, who will arrive shortly, I'm certain, and co-sponsored by Senators Leahy, Blumenthal, and Hawley, has been listed for the first time, and according to committee precedent, will be held over. We have 6 nominees who are ready for a vote today. First, we'll be considering the nomination to the Second Circuit Court of Appeals of Myrna Perez. She is an experienced litigator who has dedicated her career to defending the right to vote, a very fundamental right in America. She has demonstrated a commitment to protecting, as the late Representative John Lewis put it, our precious, almost sacred right to vote. It is fitting, then, that this committee will advance Ms. Perez's nomination so close to the anniversary of the Voting Rights Act, which is tomorrow. Her resume is outstanding, receiving degrees from Yale, Harvard, and Columbia. She clerked on the U.S. District Court for the District of Pennsylvania and the Third Circuit Court of Appeals. Practicing law, she has experience in long-running complex civil litigation and in proceedings for preliminary relief. She's given great insight into the real-world impact of judicial decision-making. Unfortunately, she has been the subject of personal attacks since she has been nominated. I want to address those directly. Some have implied that Ms. Perez acted inappropriately by continuing to do her work as a voting rights advocate while under consideration as a judicial nominee. In fact, the judicial canons apply only to nominees. Ms. Perez could not have violated these canons prior to being nominated. Ms. Perez continuing to do her work as an advocate, even while she was under consideration for nomination, is consistent with what we've seen from previous nominees. For example, now Eastern District of Missouri Judge Sarah Pitlick also worked for advocacy organizations, held over a dozen public appearances and interviews after she was in talks to be nominated. In addition, some of my colleagues have criticized Ms. Perez for her responses to questions on judicial philosophy. Let's be clear, we should not require every judicial nominee coming before this committee to pledge fidelity to originalism, whatever that is. This new litmus test is being applied very selectively. Dozens of President Trump's nominees did not label themselves originalist or didn't specify whether they followed any specific judicial philosophy. My colleagues seem to accept that answer at that time. Only now do they expect a different answer. Finally, some of my colleagues have suggested it was inappropriate that Ms. Perez stated that she believes Brown versus Board was correctly decided, but refused to give similar responses about other cases that involve issues that are before or may come before her as a judge. In fact, Ms. Perez's answer was perfectly in line with what dozens of President Trump's nominees stated at their hearings, including now Supreme Court Justice Amy Coney Barrett. These baseless attacks on Ms. Perez are disappointing. I understand that some of my colleagues do not like the fact that she's dedicated her legal career to issues like voting rights, but no reasonable person could argue that she doesn't understand the difference between being an advocate and a judge. Let me read her quote to this committee. By accepting this nomination, I am pledging to this body, to the American public, before my God, that I would faithfully discharge my duties under the Constitution, which require me to put aside any personal policy viewpoint I have and examine what the matter is before me and apply precedent. What can we reasonably expect beyond that from any nominee? Ms. Perez is independent-minded, highly qualified, and has a great background, which will serve her well in the Second Circuit. I certainly do support her. We're also voting today on Gia Cobb's nomination to the D.C. District Court for the District of Columbia. 15 years of practice, trying more than 30 cases to verdict in civil and criminal proceedings. She, in fact, her first 6 years was a public defender and then handled more than 200 cases in court almost every day. For the past 9 years, Ms. Cobb has worked at national civil rights law firms representing plaintiffs in fair housing, disability, and employment discrimination cases. The ABA has recognized her vast experience and unanimously rated her well qualified. Given that she's extensively practiced law from multiple angles, representing plaintiffs and defendants in civil and criminal cases, in public service and in private practice, I support her nomination as well. We'll likewise be considering Sarah Merriam nomination to the District of Connecticut. Judge Merriam has served as U.S. Magistrate for over 6 years, presiding over hundreds of matters. The ABA has unanimously rated her well qualified. Prior to joining the federal bench, she served as Assistant Federal Defender, where she gained extensive experience in litigation. Her nomination has the support of not just defense attorneys, but prosecutors as well. The committee's received a letter of support from 26 former prosecutors, 3 former U.S. attorneys who were appointed by the presidents of both parties. They wrote that she's highly qualified and applies the law fairly and properly. Judge Merriam has the strong support of Senators Blumenthal and Murphy. I look forward to voting for her nomination. Also on the agenda is Judge Florence Pan, nominated to the District Court for the District of Columbia, spent her entire legal career in public service in the Justice and Treasury Departments, and then as Assistant U.S. Attorney for D.C. for 10 years. When President Obama nominated Judge Pan to sit on the D.C. Superior Court in 2009, the Senate confirmed her by voice vote. Since then, she's presided over 656 trials, civil and criminal. She was previously nominated by President Obama to the D.C. District Court in 2016, favorably reported out of this committee by a voice vote. However, Senator McConnell refused to allow a floor vote on her nomination at the end of the 114th Congress. The ABA rated her unanimously well qualified. She has the strong support of the D.C. Representative Eleanor Holmes Norton. She'll bring diversity to the D.C. District Bench as the first Asian American to serve on that court. We'll also be voting on Karen Williams' nomination to the District of New Jersey. Since 2009, she served as federal magistrate judge, handling thousands of cases, presiding over trials. Before her appointment, she spent nearly 2 decades in legal practice, developing expertise in municipal and labor law. Again, she's been rated unanimously well qualified by the American Bar Association, has the strong support of her state senators. Finally, voting on Matt Olson's nomination to serve as Assistant AG for the Justice Department's National Security Division. He spent more than 2 decades in government service, developed extensive knowledge in national security and intelligence. Having already served as Acting Assistant Attorney General for this division, Mr. Olson understands firsthand the vital role that the Justice Department plays in combating threats, foreign and domestic. Coupled with his service in the intelligence community, there's no doubt he has a keen awareness of the threats our nation faces. A number of my Republican colleagues have taken exception to Mr. Olson's remarks that he made as a private citizen, but the evidence is clear. Mr. Olson, who has served both Democratic and Republican administrations, has always put the nation's security ahead of partisanship. It's this commitment to keeping our nation safe that led scores of former Department of Justice and other national security officials to write letters of support. Among those supporting Mr. Olson are numerous Department of Justice officials appointed by President Bush, Michael Mukasey, and Michael Chertoff, former NSA Director General Keith Alexander, and former Director of National Intelligence Mike McConnell, and Saxby Chambliss, our former colleague who served as Vice Chair of the Intelligence Committee. This kind of bipartisan support speaks volumes. Now I turn to our ranking member, Senator Grassley.
Thank you, Mr. Chairman. Before I tell my colleagues here why I'm going to vote against 3 nominees and for 2 nominees, I'd like to discuss another person that's still before the committee that we haven't taken action on, and that is Mr. Chipman, and I'm going to comment on that because there's been some recent press reports about his nomination and about the individual, and I think everybody understands that there's a big gulf between what Republicans think about Mr. Chipman versus what Democrats think about him. My colleagues and I have sent Chairman Durbin 2 letters requesting that he be brought back before the committee for further questioning. As we noted in our most recent letter, it seems every day there's new information concerning how unfit this individual to be head of ATF. Yesterday, we learned that Chipman failed to disclose a TV hit that he did with a Chinese government station. Now imagine if a Trump nominee had gone on the program called Russia Today to criticize Obama policies. That is what this nominee and his interview was like. The video is on the internet for anyone to see. In it, he simply nods along as Chinese propagandists paint the United States as a violent war zone. His position in the video, his positions don't seem all that different from what he says often. But it's one thing to criticize the laws and cultures of your country to a domestic political audience. It's another thing entirely to do so in the service to foreign antagonists. A country that puts Uyghurs in concentration camps, a country that executes people to harvest their organs and sell them. The Chinese Communist Party isn't interested in reforming America's gun laws. It's interested in weakening its primary global competitor by sowing political discords. This should be obvious, and yet apparently it wasn't obvious to Chipman. He needs to address this, and perhaps he would have last time had he not left the appearance of in this video off his questionnaire. Just last week, we also saw corroboration of allegations that Mr. Chipman had made racially insensitive comments while in Detroit. The chairman shot the messenger, as it were, by dismissing the corroboration as having come from pro-Second Amendment websites, but in fact is that there are numerous agents, current and former, on and off the record, who attest to these allegations, as well as problems with Chipman's time in Detroit. So, to be very clear, we didn't call for further committee action until these rumors were corroborated by independent reporting. Now that we have that corroboration, we should hear from Chipman about his time in Detroit, and the chairman should help us get the secret documents we need from the Justice Department to see what really happened at the time period in question. Sunshine is the best disinfectant after all. As I've said many times, my constituents are very concerned about Mr. Chipman, and it is a sentiment that I also share. But these corroboration allegations and his Chinese propaganda video go beyond Mr. Chipman's policy views to character, effectiveness, and judgment. If the administration is going to insist on this nominee to lead ATF, I think the committee needs, at a minimum, to ask him more questions. Now, turning to today's nominees, and as I start out, Mr. Chairman, judicial canons aside or not, I will be voting for Myrna Perez. While she seems very sincere in her progressive views, I think she's pretty clearly the most outspoken liberal judicial nominee we've seen in this administration, and of course that's saying something. Senator Schumer spoke of how she will forcefully advocate for righteousness of her causes to other judges on the Second Circuit. That doesn't sound like the role of a judge to me. That should be disqualifying. Chairman Durman said her article published the night before her hearing, slamming voting integrity legislation, was the sort of thing he could say in the speech on the Senate floor. As Senator Cotton observed, that doesn't make the point my friend, the chairman, intended to make. She's not running for partisan political positions. The fact is that Ms. Perez did nearly 20 events or articles on highly controversial questions of law and policy while being vetted by the Justice Department for this position. She's even attacked an amicus brief by committee Republicans weeks before she knew her nomination would be in front of us. Did she not care? At least trying to look impartial. Did she just assume she could count to 51 without us? Was she so passionate she couldn't help but speak her political mind? To me, there is no explanation for the truly brazen behavior that doesn't reflect poorly on Ms. Perez's judgment and caused me to question her protestations that she'd put all this aside as a judge. She couldn't stop being an advocate up through the day before her nomination hearing. I'll also be voting against Judge Merriam and Ms. Cobb. While they are qualified, I appreciated how forthright they were in answering my questions. Their background in liberal politics and advocacy are simply too much. I will also be voting against Matt Olson. Like many of President Biden's Justice Department nominees, Mr. Olson had an admirable career as a non-political public servant until President Trump took office. Then it's like the switch got flipped, and he suddenly was full-blown partisan, a member of the resistance. I'm skeptical that return to power that switch will get flipped back. Lastly, I will be supporting Judges Pan and Williams. As I said at her hearing, I remember Judge Pan from her previous nomination. I think her time as a prosecutor and a judge make her well qualified for this position. She doesn't have an activist reputation. Judge Williams, very similar. Her work as a magistrate doesn't appear activist like many of the others we've seen in the committee this year, and her time defending municipalities and police departments give her good diversity of perspective. Thank you very much.
Thank you, Senator Grassley, and thank you for the French lesson this morning. We appreciate that very much.
Mr. Chairman.
I'll be right with you, Senator. Let me just say a word about Mr. Chipman. This charge of being racially insensitive, the source, of course, is an advocacy group which has never supported him, and that's understandable. But the sources, my friends, fellow lawyers and others on the Judiciary Committee, are anonymous, continue to be anonymous. People are not stepping up to speak up on the record. And if you're going to condemn a person and their aspirations to serve in important offices, I think that's the least that should be asked. And let me also suggest this new theory against Mr. Chipman, and it seems like there's one every week, is that he is somehow a pawn of the Chinese Communist Party because he was interviewed by their Chinese television station. Senator Grassley went so far as asking us to imagine, just imagine, what if it had been a Trump nominee who had appeared on Russia Today? We don't have to imagine. As a matter of fact, President Trump appeared on Russia Today in September of 2016. So I don't think anybody's suggesting he is or was a Russian agent because of that appearance. So Mr. Chipman's not on the agenda. I'm not going to dwell on that, but I will address the issue of Monica Perez before recognizing Senator Feinstein. We understand that hers is a nomination that many of you oppose. I think she has an extraordinary background, which she brings to this job, and I believe that she would be an excellent judge on the Second Circuit. So I'm going to recognize members who wish to speak to that nomination, Monica Perez, before we take a vote. Senator Feinstein?
Thanks very much, Mr. Chairman. I want to point out, excuse me, that Ms. Perez is an experienced litigator. She spent the majority of her career protecting the right to vote. She's a graduate of Yale with a master's degree in public policy from Harvard and a law degree from Columbia. You can't do better than that. Ms. Perez has an impressive academic pedigree. She could have done many things with her career, but she decided to use her talents as an advocate for civil rights. For the last 15 years, she has worked at the Brennan Center for Justice at New York University School of Law, where she has become one of the nation's leading experts on voting rights. In her hearing before this committee, she demonstrated her deep intellectual engagement with issues at the core of our Constitution. Her commitment, excuse me, to justice is strong, and I believe strongly she's going to make an excellent addition to the federal court. Could I touch on a second nominee, and that's Matt Olson, who has been nominated to lead, should I wait for that, Mr. Chairman, the National Security Division?
Go ahead and make your statement if you
Okay.
wish, Senator.
He has been nominated to lead the National Security Division. He has a long record of protecting our national security interests, graduate of the University of Virginia, Harvard Law School, spent more than 2 decades in government service. Deep experience includes leadership roles with Justice, the NSA, and the National Counterterrorism Center. He is a strong believer in that national security decisions should not be partisan, and his record indicates this commitment. His nomination has been endorsed by a wide range of national security officials of both parties. He's an experienced national security professional. He's needed at Justice, and I look forward to voting in support of both he and the other nominees as well. Thank you very much for the...
Any other senators seeking recognition on Myrna Perez? Senator Lee.
Thank you very much, Mr. Chairman. I'd like to speak about Myrna Perez. I also just, in passing, like to pass along my concerns about David Chipman. We've got a letter dated August 3rd from 7 ATF agents who have expressed their grave concern with Mr. Chipman's personal views about firearms and what negative impact that would have on ATF. I've expressed my grave concerns with this nominee in the past. I won't repeat all of them here, but I would say this goes far beyond anything about any media reports. It goes far beyond allegations of racism. It also extends to and very much includes his strident views that are in opposition to those that need to be held by someone wanting to head that department. Mr. Chairman, I strongly oppose the nomination of Ms. Perez to the United States Court of Appeals for the Second Circuit. I'm really concerned about the troubling lack of respect Ms. Perez has exhibited towards those with whom she disagrees. Just a few months ago, she stated in a panel discussion on Justice Brennan's theory on constitutional interpretation. She made the following statement. This is an exact quote. Quote, "If you're one of these people who think that we are at our best when our country was first founded and didn't include women or people of color without property in the electoral process, this is probably not the conversation for you," close quote. Now, Ms. Perez never denounced her statement. On the contrary, she justified it, and she stands by it. And she repeatedly refused to clarify to whom she was referring, but I read that statement, and I still read it as a direct attack on people like me, who are textualists and who are originalists. Now, it's worth noting here that originalists believe that the protections of the Constitution, the provisions of the Constitution, including, of course, amendments ending slavery and guaranteeing women's right to vote, should be interpreted as they were understood at the time they were adopted, the original public meaning. In other words, not according to the imaginative whims of unelected judges. So Ms. Perez's statement, as applied to originalists, isn't just uncharitable, it isn't just unkind, it's just plain wrong. Similarly, in March of this year, she characterized election security laws as being passed due to, quote, anxiety over the browning of America, and people having anxiety over the fact that certain folks in power are not going to be able to stay in power, close quote. Now, it's actually a radically vitriolic statement. The subtext is really clear. If you support measures to secure our elections, you're a racist. That is what that means. It doesn't require any interpretive device there to figure that out. It's not at all subtle. Now, it's one thing to have a good faith disagreement over election reforms. It's one thing to have a good faith disagreement over the best set of policies to govern the manner in which we choose our elected officials. But it's quite another thing to accuse your opponents of being racist and evil. That's simply wrong, and it's certainly not the kind of disposition we want in people who will sit on the highest courts in our system. Likewise, in 2018, she described the practice of updating voter registration lists to account for people who have moved out of a particular state or who have passed away as insidious. Now, again, this is not a criticism of the policy. It's an attack on the motives of the people promoting it. Ms. Perez's readiness to demonize those with whom she disagrees, and not just to demonize them generally or denigrate them in some abstract terms, but truly to set them aside as sexist, racist, or evil, strongly suggests that she lacks the kind of even-handed, fair-minded temperament that's required for service on the federal bench, especially at a level where she would be serving, if confirmed to this court, on what is often the court of last resort for most litigants passing through the federal judicial system. Second, I'm concerned by Ms. Perez's radical views regarding election security. She spent her entire legal career opposing common sense election security reforms, including voter ID laws. She's also she's engaged in irresponsible rhetoric surrounding election security laws. It's recently been in vogue for Democrats to irresponsibly pretend that unobjectionable voting laws, like those passed in Georgia and in Florida, somehow constitute a reincarnation of Jim Crow. It should be noted that Democratic states with similar restrictions, like Connecticut and Rhode Island, conveniently escape this kind of condemnation. Funny how that works. I wonder if it's a coincidence. Ms. Perez is no stranger to this kind of careless rhetoric. In fact, she's a bit of a thought leader on this kind of false equivalence. Back in 2014, she described election security laws passed by 22 states as representing, quote, the biggest voting rights rollback since the Jim Crow era, close quote. It's not an exaggeration. Those are her words. That's a direct quote. This kind of talk was dangerous and irresponsible then, and it is now. And it's also an insult to the brave Americans who engaged in the civil rights movement to draw any comparison between Jim Crow era voter suppression, unilaterally imposed by the Democratic Party, by the way, and today's common sense, race neutral, and often bipartisan election security measures. It's also worth pointing out that Ms. Perez's views on election security are popular with Americans across the political spectrum, including minorities. The voter ID laws she's criticized so harshly, so viciously, enjoy the support of 75% of all Americans, and notably 69% of Black Americans. It's a lot of support for a policy that's supposedly as bad as Jim Crow. Third, Ms. Perez's responses to this committee, both in person in her hearing and in follow-up questions for the record, conform to a broader concerning trend that I've seen regarding President Biden's judicial nominees. Many nominees, including Ms. Perez, have failed to engage in the most basic discussions about their method for deciding cases, about the method by which they'll construe statutory text. In other words, their judicial philosophy. Merely stating that one will interpret the text of a statute and apply the law to the facts, which seems to be the canned answer that they've been coached to provide, is an insufficient answer. Indeed, every judge starts with those premises. That's what judging is. There's nothing more to judging than that. If the job were truly that simple, then judges wouldn't regularly arrive at different conclusions on different legal issues, like voting laws. The disagreements, of course, occur because of judges' differing philosophies, be they originalism, living constitutionalism, or some unarticulated, enduring alternative that necessarily guide and influence a judge's interpretation of the text and application of the law. Put simply, every judge has a judicial philosophy. And if they say they don't, they're either unqualified or they're hiding something. But time and time again, President Biden's judicial nominees have done just that. They've each parroted a variation of the same line. I have no judicial philosophy. Under follow-up questioning, they refused to engage in meaningful discussion regarding how they would go about deciding cases, how exactly they would construe the meaning of a statute. That's like a preacher telling a potential church that they have no theology, but they plan to get one if hired. If it's true, it's extremely troubling and potentially disqualifying. If it's not, then why would they refuse to talk about it? Look, I'm not trying to find out what someone will decide, but members of this committee deserve to know how a nominee, if confirmed to a lifetime tenured appointment on an Article III court, would do their job, how they would do their job, how they would construe statutory and constitutional text. nor am I expecting President Biden's nominees to agree with my judicial philosophy. They don't even have to associate themselves with any named judicial philosophy, but they should, at a minimum, be able to discuss how they would do the job they're applying for, rather than just describing what it is that judges do as a conclusory assertion. Fourth, and finally, I'd like to make a global observation regarding the qualifications, or lack thereof, of many of President Biden's nominees. On several occasions now, we've had nominees come before this committee who have failed to answer basic questions that most American lawyers, and in some cases, even most first-year law students, would and should know the answers to, including, for example, the number of jurors in a civil jury trial, basic standards of constitutional review, like rational basis scrutiny. Hint, it's in the name. What kinds of cases federal courts are allowed to hear? Now, one nominee answered that subject matter jurisdiction could be waived. It most certainly cannot. And in some cases, the content of provisions in the Bill of Rights. One nominee clearly wasn't familiar with the Seventh Amendment. Now, look, I'm not trying to be nitpicky. True, these are not the kinds of questions that the average citizen would be able to answer perfectly, although that would be great. It would actually be really cool. But that's just the point. Federal judges have to know this stuff. It is their job. Federal judges have tremendous responsibility. In some cases, they literally hold the power of life and death. And so I can say without hyperbole that it's imperative that they get it right. And we've seen far too many nominees who have been nominated to a lifetime tenured appointment to an Article III court from this administration, who have given us substantial reason to doubt that they're up to the task. To err is human. Everybody makes mistakes, forgets something sometimes, but to forget to not even know at the outset some of the most basic fundamentals of what's involved in being a federal judge is troubling. The bottom line, the administration needs to do better. The American people deserve better and should expect more, as should we.
Mr. Chairman,
Senator from Vermont.
Chairman, I don't want to generalize too much, but I've sat in hearings before, or markups before this committee for decades, and I see things like the personal attacks against a nominee like Myrna Perez. She's eminently qualified for circuit judgeship, and I know that Second Circuit, I've argued many cases before I was in the Senate. I've gone back through all the notes and all the arguments, and it seems that whenever female nominees are before us, and particularly female nominees of color, members of this committee, some of them, lose their ability to tell fact from fiction. They lose their cool. I don't mind contesting a nomination based on an accurate assessment of nominee's record. But it becomes all too obvious that female nominees of this administration bear the brunt of being labeled with names and other. I'd note that Myrna Perez has spent her life protecting the voting rights of Americans. Protecting the right to vote should not, indeed it must not, be a partisan issue. It's the whole point of democracy. And maybe, I hope it's just pure coincidence. There seems to be more of an attack on women, especially women of color, by some in this committee, but the numbers seem to say it's more than just an accident.
Anyone else seeking recognition? Senator Cruz.
Thank you, Mr. Chairman. I want to talk about Myrna Perez, but first I want to talk about, put that down right now. First I want to talk about priorities of this committee. This committee, I believe, in the year 2021 has had a consistent pattern of focusing on partisan priorities of Democrats at the expense of fulfilling our responsibility to the American people. When it comes to immigration, we've had not one, not two, but 3 hearings on amnesty. That clearly is the partisan priority of President Biden and Democrats in the Senate. We've had not a single hearing on the disaster, the catastrophe that is unfolding on the southern border. This week, news broke that was particularly chilling. The mayor of McAllen, Texas, announced that in the last 6 months, Joe Biden and Kamala Harris have released over 7,000 illegal immigrants into McAllen who were COVID positive. The mayor further announced that last week, in 1 week alone, Joe Biden and Kamala Harris released 1,500 illegal immigrants into McAllen who were COVID positive. Now, to put this in perspective, the population of the city of McAllen in 2019 was 141,000 people. 7,000 illegal immigrants, all COVID positive, is roughly 5% of the population of that city. The mayor rightly declared it a disaster in South Texas. And at least to date, the answer from congressional Democrats is that nobody cares. The Biden administration is releasing thousands upon thousands of illegal aliens with COVID into communities, spreading the pandemic, and this committee's too busy holding hearings on amnesty to even hear testimony. Mr. Chairman, I would ask you to bring the mayor of McAllen up here to testify about the consequences in that community on the Rio Grande border of the Biden administration releasing thousands upon thousands of illegal immigrants who are COVID positive. It is wildly irresponsible, and it's dangerous. Secondly, in terms of priorities, the nomination of David Chipman raises very serious concerns because his record is that of someone with an extreme gun control agenda. Indeed, he argued that Senate Democrats' proposals to ban guns don't go nearly far enough, that he wants to go much further than, for example, Senator Feinstein's bill. He's entitled to those views, but those views are out of step with the mainstream of America. Since his hearing, even more disturbing information has come to light, in particular, 2 different sets of allegations. One, an article from The Reload, July 28, 2021, entitled, "ATF Agents Corroborate Existence of Racial Complaint Against Biden Director Nominee, Fear Reprisals, and Hit to Agency Effectiveness." And the article says, multiple ATF sources back up the existence of a complaint alleging President Biden's nominee to lead the ATF, David Chipman, made racist comments during his previous stint at the agency. The article goes on to quote one of those ATF agents, quote, "He made some comments that he was surprised by the number of African Americans who have made it onto a specific promotional list. So his insinuation was that they had to have cheated, which is kind of despicable." The article further quotes an ATF agent as saying, quote, "He left Detroit because of that. He did not leave Detroit on the best of terms. His reputation was that he was not nice to people." These are troubling allegations, and yet the chairman of this committee has said it's not worth the committee's time to have a hearing and to let Mr. Chipman answer these allegations. Apparently, Senate Democrats do not care if he made racist comments in his role in office as a supervisor. They do not care if he created a racially discriminatory and hostile environment by making racist comments. Now, he may have a defense on this, but if he does, we don't know it because this committee can't be bothered to have a hearing and ask him. So what this committee is saying is that allegations of racism, if you're a partisan Democrat, no problem at all. Not even worth asking about. Secondly, another story that is broken This is from a story in Fox News on August 5th, 2021, entitled Biden ATF nominee Chipman failed to disclose Chinese state TV hit used as propaganda by the communist state. And it explains that, quote, President Biden's nominee to head the Bureau of Alcohol, Tobacco, Firearms, and Explosives failed to disclose to the Senate a media appearance on Chinese state TV, which may have been used as propaganda by the communist state to cover up a mass stabbing of children. Now, the chairman defended that as saying, well, other people have gone on state TV, perhaps. Did Mr. Chipman know that he was going on a communist propaganda show? Did he know that it would be used as propaganda to tear down America? Did he know that it would be used as propaganda to cover up the atrocities in communist China? We don't know. We don't know because this committee hadn't had the chance to answer them, and what the committee leadership is saying is they don't care. Doesn't matter. Truth doesn't matter. We got a partisan agenda to do. Don't bother us with actually doing our jobs. And so I would ask unanimous consent that both of these articles be entered into the record.
Without objection, thank you very much, Senator, for your comments on favorably reporting the nomination. of
Mr.
Miriam
Chairman,
Perez.
I'm not completed.
I'm sorry. How much more time do you need?
5 to 10 minutes. As I said, I wanted to talk about Myrna Perez.
She is the nomination before the committee.
Yes, that's what I'm prepared to talk about right now.
I hope the senator will be mindful of the other senator's time when he uses his own.
Well, I am mindful of the other senators' time. I'm also mindful that this committee spends a ton of time on things like amnesty and not time on doing our jobs. So this committee doesn't have time to look into allegations of racism, doesn't have time to look into allegations of participating in Chinese communist propaganda, doesn't have time to look into the Biden administration releasing thousands of illegal aliens with COVID, but we have time to move political activists forward to satisfy the partisan interest of Democrats in the Senate. Let's talk about this judicial nominees. President Biden's nominee to the circuit courts have been uniformly problematic. One nominee, Gustavo Gelpi, has demonstrated record of activism from the bench and has routinely made comments that are in conflict with Canon 3A6 of the Code of Conduct of Federal Judges. Another nominee, Eunice Lee, has zero experience practicing in civil cases, yet was nominated to a court where 83% of the new appeals are civil. The nominee couldn't even tell Senator Cotton when a litigant is entitled to a jury trial, much less how many people actually sit on a civil jury. And yet, out of all the circuit nominees that we have seen so far, Myrna Perez is the most dangerous. She has been a radical and an activist for what effectively amounts to her entire career, having spent the last 15 years advocating for extreme far-left positions. She has waged campaigns against voter ID laws, describing them as the greatest rollback of voting rights in the country, even though 80% of Americans support voter ID laws and 60% of African Americans support voter ID laws. Even though voter ID laws have been upheld as constitutional by the Supreme Court in an opinion authored by Justice John Paul Stevens, one of the great liberals to serve on the court. She has opposed voter integrity laws almost across the board. And she's not just opposed to them as a matter of law. She said anyone who disagrees with her radical views and believes in ensuring the integrity of our elections must be a racist. Just 5 months ago, she said that many of the voting laws being enacted across this country are due to, quote, anxiety over the browning of America, and people having anxiety over the fact that certain folks in power are not going to be able to stay in power. I'll tell you, the folks in power that want to stay in power is Democrats in the Senate who are trying to rig the game so the voters can't vote them out. Ms. Perez is opposed to laws that would prohibit ballot harvesting, a practice that invites fraud and abuse. She went so far as to say the Democratic Party's challenge to an Arizona law prohibiting ballot harvesting was clear-cut, and that an amicus brief that I led on behalf of 11 senators supporting that common sense law was, quote, outrageous and dangerous. Supreme Court, thankfully, did not agree with Ms. Perez's left-wing views, and indeed, by a vote of 6-3, agreed with the position advocated in my amicus brief, which is that common sense bills prohibiting voter harvesting are constitutional. Ms. Perez has also argued the Constitution requires allowing felons to vote, even though the 14th Amendment explicitly in the text recognizes that states have the ability to prohibit felons from voting. So never mind what's in the Constitution. She's prepared to read it to mandate the policy outcome she wants. Text be damned. Now, a shrewd observer may think, where have I heard all of these policy positions before? And the answer, of course, is S1, the Corrupt Politicians Act. If Ms. Perez is confirmed, she will be the judicial equivalent of a judge who will mandate the Corrupt Politicians Act. Never mind getting it through Congress. You may not have the votes in Congress, but if you put an activist judge on the bench, she can order the policy outcomes you like, never mind the law. Banning voter ID, you betcha she'd do it in a heartbeat. Requiring states to allow ballot harvesting, check. She's going to be there too. Allowing felons to vote, you betcha. Prohibiting voter integrity laws, 100%. And that's exactly what Democrats want on the bench. Democrats have a long history of trying to get through activist courts what they can't get through the democratic process. And that's what they're trying to do with Ms. Perez. They can't pass the Corrupt Politicians Act, so they're trying to do the next best thing, which is confirm a radical to the bench who will impose those policies from the bench. And the amazing thing is, Senate Democrats are not even hiding the fact that Ms. Perez has been nominated precisely because she will be a partisan from the bench. Senate Majority Leader Chuck Schumer, in a moment of raw honesty, went off script when introducing Ms. Perez at her hearing, and he said that he wants Ms. Perez on the bench because she will, quote, persuade fellow members of the Second Circuit to the righteousness of the causes that she will follow. Well, I appreciate Senator Schumer's candor. And if you were nominating someone to be a left-wing activist, this would be one heck of an endorsement. But this is damning for a judicial nominee. Chuck Schumer is telling Democrats this is going to be a righteous advocate of causes. Throw out all pretense of judicial objectivity. Throw out all pretense of following the law. She's going to be a left-wing activist. And it's not only Senator Schumer that has let slip Ms. Perez's political activism. Chairman Durbin praised an article she wrote entitled, quote, "The GOP Campaign to Make Elections Less Free." Chairman is nodding. He apparently thinks it's a good thing for federal judges to be blazingly partisan. Chairman Durbin said he would, quote, gladly give her article as a speech from him personally on the floor of the Senate any day of the week. Mr. Chairman, I agree. You're a partisan Democrat. You're entitled to be a partisan Democrat. We shouldn't have judges that treat the judiciary like they're partisan Democrats. I will note Senator Leahy said a minute ago, the reason for Republicans' opposition is she's a woman. Now, call me crazy, but I seem to recall a hearing not that long ago for a judge named Amy Coney Barrett, who had extraordinary academic background, who had an extraordinary record, and who every Senate Democrat happily voted against, who Democrats on this committee asked Judge Barrett, have you ever sexually assaulted anyone? That was a unique moment in the history of the Judiciary Committee. Democrats on this committee had previously said about her Catholic faith, the dogma lives loudly in this one. Now, I'm not going to suggest that that was because she was a woman, which is what Senator Leahy suggested of our concerns with this nominee. I'm going to suggest it's because Democrats want left-wing partisans on the bench, and Justice Barrett is not a left-wing partisan. Neither Senator Schumer nor Chairman Durbin is wrong about Ms. Perez. She's given us every reason to believe that she will continue her radical activism if she's confirmed. Nominees who care about the judicial role, who care about the appearance of bias, who care about demonstrating a judicial temperament, will take on a judicial role as soon as they even think about the possibility of becoming a judge. But Ms. Perez has demonstrated, even when she was in the process of being nominated to the court, she's a partisan, and a partisan she will stay. After she had submitted her judicial application, after she'd had multiple conversations with a member of Senator Schumer's screening committee, speaking with Senator Schumer's staff, personally interviewing with Senator Schumer to be a judge, she continued to engage in rank partisanship. About a week after interviewing with Senator Schumer, she spoke on a virtual panel where she said that voting integrity laws were the result of, quote, anxiety over the browning of America. Ladies and gentlemen of America, get ready for a judge in a robe who, if you disagree with her political policy, is going to call you a racist from the bench, because she was prepared to call anyone who disagreed with her a racist while she was interviewing to be a judge. Later, even deeper into the process, when she was in contact with the White House counsel's office, she disparaged originalists as, quote, people who think that we were at our best when our country was first founded and didn't include women or people of color or people without property in the electoral process. So apparently, Judge Perez is saying Clarence Thomas, who's an originalist, thought we were better when people of color were not allowed to vote. She's saying Justice Barrett, who's an originalist, thought we were better when women weren't able to vote. What utter garbage. That's not what any rational, reasonable, fair-minded person says, but it is what a left-wing activist and extremist says. And she did this when she was deep into the process of being considered to be a federal appellate judge. Senator Schumer, Chairman Dermott are both right. This nominee is and always has been a left-wing activist. And if she's confirmed to the Federal Court of Appeals, she'll continue to be a left-wing activist. Unfortunately, that's what our Democratic colleagues want. In a moment, we're going to vote on this judge, and I'm going to predict that every single Democrat is going to dutifully salute and say aye. Confirm the activist. To heck with judicial independence. To heck with judicial temperament. To heck with following the law. We have a left-wing partisan agenda, and we want judges to force them on the people. Never mind democracy. Never mind the will of the voters. We want to exercise power. When it comes to priorities, I think that is a profoundly misplaced priority.
On favorably reporting the nomination of Myrna Perez to be U.S. Circuit Judge for the Second Circuit, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein. Mr. Whitehouse. Ms. Klobuchar. Mr. Kuhn. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
No.
Mr. Graham.
Aye.
Mr. Cornyn.
Aye by proxy. No by proxy.
Mr. Lee. Mr. Cruz. Mr. Sass.
No by proxy. In the back.
Mr.
The nomination will be favorably reported to the floor. On favorably reporting the nomination of Gia Cobb to be U.S. District Judge for the District of Columbia, the clerk will call the roll.
Mr. Leahy. Mrs. Feinstein. Mr. Whitehouse. Ms. Klobuchar. Mr. Kuhn. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
No by proxy. No.
Mr. Graham.
Aye by proxy.
Mr. Cornyn.
No by proxy.
Mr. Lee.
Aye.
Chair Durbin, the votes are 13 yeas, 9 nays.
The nomination will be favorably reported to the floor. On favorably reporting the nomination of Sarah Miriam to be U.S. District Judge for the District of Connecticut, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
No.
Mr. Graham.
Aye by proxy.
Mr. Cornyn.
No by proxy.
Mr. Lee. Mr. Cruz. Mr. Sass.
No by proxy.
Mr. Hawley. Mr. Cotton.
No by proxy.
Mr. Kennedy. Mr. Tillis. Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, the votes are 13 yeas, 9 nays.
The nomination will be favorably reported to the floor. I understand we can take a voice vote on the Pan nomination.
I'd like to request a roll call vote, Mr. Chairman.
Okay, so will. On favorably reporting the nomination of Florence Pan to the U.S. District, be District Judge for the District of Columbia, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
Aye.
Mr. Graham.
Aye by proxy.
Mr. Cornyn.
Aye by proxy.
Mr. Lee. Mr. Cruz. Mr. Sass.
No by proxy.
Mr. Hawley. Mr. Cotton.
Aye by proxy.
Mr. Kennedy. Mr. Tillis. Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, the votes are 18 yeas, 4 nays.
The nomination will be favorably reported to the floor. On favorably reporting the nomination of Karen McGlashan Williams to be U.S. District Judge for the District of New Jersey, the clerk will call the roll.
Mr. Leahy. Mrs. Feinstein. Mr. Whitehouse. Ms. Klobuchar. Mr. Coons. Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
Aye.
Mr. Graham.
Aye by proxy.
Mr. Cornyn.
Aye by proxy.
Mr. Lee. Mr. Cruz. Mr. Sass.
No by proxy.
Mr. Hawley. Mr. Cotton.
No by proxy.
Mr. Kennedy. Mr. Tillis. Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, the votes are 16 yeas, 6 nays.
Nomination will be favorably reported to the floor. On favorably reporting the nomination of Matthew Olson to be an Assistant Attorney General, National Security Division, the clerk will call the roll.
Mr. Leahy.
Aye.
Mrs. Feinstein. Mr. Whitehouse.
Okay.
Ms. Klobuchar. Mr. Coons.
Thanks, Ben.
Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Padilla. Mr. Ossoff. Mr. Grassley.
No.
Mr. Graham.
Aye by proxy.
Mr. Cornyn. Mr. Lee. Mr. Cruz. Mr. Sass.
No by proxy.
Mr. Hawley. Mr. Cotton.
No by proxy.
Mr. Kennedy. Mr. Tillis. Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, the votes are 13 yeas, 9 nays.
The nomination will be favorably reported to the floor, and the meeting stands adjourned.